Okay. Oh, we are live. And this is Senate Health and Welfare, Wednesday, April 24th. And we have a number of bills we're going through. And some of them are bills that are not in the committee, but things that we have to pay attention to. So first, we're looking at H661. Ben, that's me here.
So for the record, Ben Obroski from the Office of Legislative Counsel. For the committee is draft 1.2 of an amendment to H661 with highlights of the majority of the changes for reference. This was a result of further discussion between the Vermont Parent Representation Center and UCF to figure out some of the and also to incorporate the technical changes from the memo that was submitted last week. So it's a result of continued collaboration and that's what the committee will see. So the first change is on the bottom of page 2, line 17. And I can send, you want me to post this on the
do
screen?
that because
Okay.
it's a strike all under the line. Is this a strike all? Yes.
It is. So bear with me.
Good morning, Seth.
Sorry, wait.
No.
Like you took the pressure off of me. Actually, two of you were both, so. I was here and just had to get coffee.
I never realized
Actually,
I was going.
Martine walked in the room before I did.
That's right, I was first, actually. Thank you for acknowledging that. The DP will be, it is a competition on who can be latest in this. Usually I win that award. So cool that your initials actually are Ben.
That was very intentional on the part of my mother.
So.
She said, he's gonna have a really long last name, so let me try to make his initials something workable.
Hey, Mom.
Yeah. So on to more serious matters. Well, the first change is on page 2, line 17. This was the technical corrections that came from Nancy Miller's memo about adding to the purpose section here that not only are investigations to be thorough and bias based on accurate and reliable information, but also information that's weighed against other supporting or conflicting information and the adhere to due process requirements. Any questions on that addition? And then scrolling farther down on several pages later is the addition of weather on page 8, line 4, as far as the rules for the implementation of the registry levels. And so it's now when, whether, and how names are placed on the registry, which was really just a technical oversight as was stated in the memo. Section 6 is amends 33 VSA 4916A. This was the subject of a lot of discussion yesterday about, and I think that this was raised last week about the training that a lot of the independent reviewers have and sort of the limitations of that. There were references to placements on the registry or appealing the child protection level designation. There was testimony that was outside the scope of what a lot of the reviewers are trained to do. So this section reflects that change. And substantiation, I learned this, can also includes placement on the registry. So the addition that you see here on line 16 and 17 that came from the House is going to just stay as substantiation and strike placement on the registry to be more inclusive of the term, if I got that correct. So you'll see here that subdivision 4 remains the same. There was a strike in provision 5 about reference to the child protection levels that came out of the house. So all of those were struck from this section. So it's just about substantiation, and you'll see here, intention to place the person's name on the registry, so it would just now be determination.
Oh, this feels a lot better.
Yeah.
Yeah.
Yeah. And then scrolling through, this part stayed, or led to placement on the registry, because when you read it holistically, the administrative review may be stayed upon the request of the person whose conduct is subject is a substantiation determination, if there is a related case pending in the criminal or family division of the Superior Court that arose out of the same incident of abuse or neglect for which the person's conduct was substantiated or led to placement on the registry. So it wasn't so much an appeal, it was just, and again, I'm gonna defer to my colleagues that might be able to explain the rationale a bit better than I on this.
The idea is there's no bifurcation between the processes, but there's a very narrow exception where the commissioner in his or her sole discretion may place a name on the registry pending review, and this allows for that situation.
So it would stay, the case would be stayed while there's a parallel court case, basically. I could allow for that. And then scrolling further down, this was the part about scheduling versus holding in D1. So now, after further conference with the parties, the department shall schedule administrative review conference within 60 days after receipt. And then a part that remained unchanged, but that could be extended by 60 days upon good cause, which is at the bottom of this page on line 16 through 19. That remained unchanged, but that provides a basis to extend if there's a good reason to do so. So any questions on that part, because I know it was a subject of debate last week.
I was convinced, I think, on the schedule versus hold. I said I was convinced on the schedule versus hold
Yes,
conversation last week.
right. No, this is good.
And then farther down, you'll see here, the addition of and this was to accommodate the change from the difference between substantiation and placement on the registry. So this regards that if the conference is not held due to extenuating circumstances, unless good cause is shown, the substantiation shall be accepted and the person's name placed in the registry. It was an or before, but since to keep it consistent with the changes that were made in this section, that language changed. And then farther down, you'll see these changes here, some grammatical changes on line 14, and then the most recent redress provided by the person was the technical correction suggested by the department. And then again, you'll see here, placement of the registry, or the report on the registry is deleted from the Human Services Board hearing because, again, it's a substantiation, not just placement. And then you'll see here the addition of an eligible person to a request for expungement. So you see that the commissioner shall grant a review upon an eligible person's request, because there are certain eligibility requirements based off of their conduct and the length of time.
Do we have eligible for person defined in this bill? I'm trying to remember.
We do not.
But it's elsewhere in statute.
It's not defined elsewhere in statute from my understanding, but it could be. But I think it might be hard to define because I think there are the different eligibility
Yes.
requirements
Yeah,
based off of the conduct and the length of time. But I could look into it.
we'll do that the next time.
Okay. And then farther down, you'll see here, the addition of the commissioner's decision to deny expungement petitions shall contain information about how to prepare for future expungements. This is just kind of a change in the language from the House that kind of gets at the same issue, giving people the information they need about their eligibility requirements to be expunged from the registry. And then here you'll see a change from January to April 1st. 2026 for the, rulemaking, for the rules to go into effect. And you'll see here, that there's new 7 and 8 because those provisions were struck and then made into the report that is now in section 12. Reads child abuse and neglect, substantiation, recommendations, and categories rulemaking report. So this is now required that on or before October 1st of 2025, ECF in consultation with the Secretary of Human Services, Agency of Education, DMH, Vermont Parent Representation Group, and Voices for Vermont Children shall submit a written report to the committees of jurisdiction on progress towards establishing a centralized internal substantiation determination process. And then 2 and 3 are the previous rules that were outlined, rules establishing substantiation categories that require entry onto the registry and alternatives to substantiation that do not require placement on the registry. And then rules for creating procedures for how recommendations are made to the district, by district offices to, and the central office. And then the report, required pursuant to subsection A shall include legislative recommendations, if any, and that, it shall be presented before the standing committees on before January 15th, 26. So basically the first week or 2 of the session.
Okay. Questions for Ben? Comments from around the room, if they're not, but you're all here and you've worked on this.
And Ben's done a great job.
They helped me tremendously.
Well, I think there's some clarity offered here because, and it helps with the due process
Yes.
very much. Okay. I'll be good with that.
There's one little thing.
You found a comma.
When it's pending.
A page.
Oh, yeah, I'm
Yeah.
trying to find it, yeah, sorry.
I'll find it.
I have the old version, so I don't have the page,
Oh, well,
but it's around page 12.
That won't be too far from now.
And Ben's off the hook on this one. It was the thing we didn't catch.
So just now with the when you have a review stayed pending a criminal
Oh.
case, you won't always have a case placed on the registry. So it should say shall be placed on the registry if applicable.
It's contemplating that there might be a time down the road where somebody who is substantiated does not go into the registry.
So it would be on, so page 12, line 4, just after name shall be placed on the registry, comma, if appropriate,
I would say if applicable.
if applicable.
Yeah.
Yeah.
Check. Is there anything else like that? What do we think, committee, with this one? Questions?
Yeah, I do. I still have a few questions.
Go ahead.
But then, being that everybody's in the room, both opportunity, now we're leading up to a vote, so
Getting there, but, go ahead.
I just want to express a couple things. I think I brought them up to some degree earlier in the testimonies, but Dan, can you go to page 11, line 15? See if this is still it's the default position for, it may have changed because this is the new copy. The default position for guilt.
Position for guilt.
And maybe that's my way of interpreting it, but it was line, or page 11, line 15.
I think so. Would this be the as passed by version? Do you remember the?
Got draft one. Which,
So it was
what
long-
draft are we looking at?
We're at 1.2 right now, but this would probably
Yeah, got
be
that.
the as passed by version. So you would page 11.
Line 15.
Is this about the department may elect to not hold an administrative review conference? It was the as passed by version.
If the department fails to hold an administrative review conference within 60 days after receipt, that one.
Line, so yeah, it is as passed, and it's actually on line 19. The
Okay.
departments substantiation shall be accepted. Which to me means
And the person's name placed on the registry, that.
absolutely, yeah.
Yeah.
I mean, that to me is like, it's like, it's a presumption of guilt if he's not, if he doesn't appear or likes not to, attend or maybe even doesn't know, because my second concern is that the notification process is, it's not a personal notification. And I guess what I'm reflecting on is that the implications of being put on a child abuse registry are absolutely significant. Yes, to me, it's akin to the sexual predator databases. I mean, it's a big deal. And I just think that the presumption of, well, the substantiation shall be accepted in the person's name, place in the registry. That's guilt. That's a step taken
Yes.
without those.
So, to kind of, if I may sort of elaborate on this concept, so this is sort of like a default judgment, if you will.
That's right.
Yeah, and, default judgments in courts occur when people fail to appear for their hearings, and that's what is contemplated in this scenario. And I think specifically the current concern you raised, that if people don't receive notice, they can't engage in the process, and then therefore this is a potential consequence, if I'm understanding the concern correctly.
Absolutely.
I think in that situation, since this is qualified unless good cause is shown, it's good cause. If you don't get notice and then you can't engage in the process and a judgment, for lack of better terms, entered against you, that I would be confident to say that that's good cause to not enter the default against you essentially and continue on with the process. But there is a process that you have to engage on in order to even do that.
Right.
Right.
And they have to have been notified. They have to have understood they've been placed in the registry. I mean, the ball starts rolling in all the wrong directions. And the person may not have been notified. And again, I'm not saying that the whole system is flawed. I think the bill is very good. I'm just saying that this is like, worst case. He really didn't get the notification. He's placed on the registry. He's not able to defend himself or herself. And then the effort has to be, well, now I need to clear my name. And that, I'm sure that's an enormous process. So I'm just not, so to me, the weakness starts at no personal notification.
Let me go through the notification process. Just to see what-
So let's hear from the folks who are doing the notice.
Thank you, Madam Chair. Kathleen Clark, again, Director of the Registry Review Unit. I think I can put your mind at ease with this. This is separate from the notification that comes from the district office that a substantiation has occurred. That has already taken place, and the individual has reached out to the CRU, to our unit, to say, I want a review. And in doing so, they have filled out a form they've signed with their mailing address, their phone number, and their email. We then try to contact that individual within that 60-day timeframe to set up a meeting. And they either don't return our calls, our emails, or respond to our letter, or they do, and they schedule a review meeting, and then they don't show up. So there has been an intentional effort to reach this person, and based on information they provided to us. So there has been a notice of the substantiation, and they have initiated the review process. So we're already at that stage where we know how to contact them, and then they just don't follow through. So that's the first part, dealing with the notice that might make you feel a little better about it. And then the second thing is they retain the right to appeal our decision as well. So our notification to them will say, this has been upheld, but you may appeal to the Human Services.
Okay, I get that. Can we go all the way back to the beginning though? I mean, is there any positive personal contact at the very beginning where they're accused of being a child abuser?
After the investigation,
Yeah, I mean,
That's
whether
when
they're convicted.
the notification letter is sent to the individual, and then based
Okay,
on
stop
that.
there, please. So how is it sent? It's not registered, it's just a letter, right?
It is, but if they don't get it, they would never have reached out to us at the review unit to initiate the review process. So they've been advised because they know to reach out to us and say, I want a review.
They've been accused.
Mhm.
Okay. How are they notified that they're accused?
Well, it could be by letter, it could be in person, it could be by email. It's however the district office lets them know. And then once they know, they
How are
reach
you
out to us.
required to contact?
So by letter.
We went through this in testimony, that's still what left me very uncomfortable.
Right,
And,
so I
and up
think-
on the screen too, I've put on some language or put up some language that everybody could, you know, that the House has addressed to make sure that the identity of the person is acquired and then their essentially best way to contact them. That's what happens at the initial, once complaint is received and assessed.
So there's a mail or email.
So Nancy Miller, I'm the Child Safety Manager with Family Services Division. And I oversee policy and practice on the front end, so child abuse investigation. And so, both by statute and by policy, we are required to make every attempt possible to notify the alleged perpetrator of the allegations against them. And that is done either in person, by phone, by email. Oftentimes it is done in conjunction with law enforcement. There are times when people who are accused do not want to meet with the department. And if their attorneys have advised them to not meet with the department. And in those situations, if the attorney reaches out to us, then we will provide notice through the attorney, like we would like to interview this individual, try to set up times. And so that in-person contact is attempted in a variety of methods at the beginning of the investigation. Most of the time we're successful. Most of the time people do meet with us. There are times when folks, despite our best efforts, simply do not want to engage in the process. And in those cases, we rely on mail. And now with the new statute, we will be relying on mail of their last known address and email if they've provided that information
But
to
not
us.
required to be positive personal contact.
That happens in the beginning if they want to be. This is I'm hearing what you say and I remember all those cases. In cases that are problematic where public safety needs to get engaged and it's just,
It's a big deal.
it's a big deal. So Senator Williams had a question. Okay, and then Senator Hardy and then Larry will turn to you for some comment.
Okay. I think at this point in the process where you're concerned that it's a review, so they've already had contact and they already are engaged in it. So it's not a question of, do they even know? They do know, they've asked for a review. So they have, at this point, skin in the game and they are in contact with the department.
Okay. I hear you, but I'm reading what's written in black and white, and it doesn't say that. It says email or mail, and initially, the initial contact.
Then there might be a conversation either through the lawyer or with the individual. What's the best way to contact you? And so they'll say email or mail or phone or whatever it is. So it's not like it's a blind system. So Ben, you want to say?
Yeah, and just if I may, because there's the initial receipt of the complaint, assessment, the investigation, and then the substantiation. This portion here that we were originally discussing is only if, and as Senator Hardy was saying, it's only if a review is requested. To
Okay,
do that.
not the initial notification.
No.
No. So where's the language in initial notification if there's some positive personal contact?
It was that the portion before about they have to use essentially best efforts, the investigator, to contact those people and acquire their contact information. Yeah. And all.
Larry, do you want to comment while we're?
I would just add on the front end piece, your concern is well taken. And it's been an issue of discussion for over a year with the department of how to resolve this. One of the ways that we are trying to address it, I think, is that the department now maintains a log system. Who sends the letter? When did they send it? Who was the person who put it in the mail? And that was missing before. So there were questions about, did a letter ever, was the letter ever received? The feeling is that at least now there is a trail that we can go back to say, look, we collected, the department collected the mailing address, an email address, a phone number. The letter had to be sent, the statute says the letter has to go, and there needs to be a backup way to do that. Now there's a law that says the letter was sent, it went out. Did it come back in the mail as undeliverable? Then you try whatever the next contact way is. We could not find a way to actually ensure that there was a documented personal connection. Because if it was done verbally, that would be recorded by a worker in their notes. If it was done over the phone, that would be recorded. But it was just not possible, and we spent hours trying to figure out how do you make sure that somebody looks at the individual and either hands them something or tells them something, and you're sure it happened. We just couldn't come up with anything. I'll give you one example. There's one individual whose review has occurred. I can't reach them. I can't find a way to reach the person to tell them that they need to appeal at this point because they've apparently changed an address, they've moved, they've done something. But I have no way of reaching them at this point. So the department, I think, by maintaining a universal log that's used statewide is the best source we have of saying, okay, now we can say it was mailed. Because in hearing, we can bring someone in, we can look at the log and say, okay, all right, if there's no log, if there's no entry in the log, then you can't say that you sent a letter, which we can't really do now because that log hasn't been implemented, but it will be, and it has been implemented in some places. Is that fair to say?
It's a good step, but still wondering about this. I don't know.
I was just gonna say, it just seems like at that point, it really would behoove the person to be contacting the necessary, to be plugged into what's going on and not,
Yeah, I agree with that.
So-
That's reasonable thinking.
yeah,
But we're talking about worst case
well,
and there's, no positive contact. The best efforts of the investigator. Yeah, I get that, but it's still a little weak.
well, is that the same kind of effort that is made in court cases?
That's
I mean,
exactly it.
in the court, they make the best effort to contact people, so I don't know that this is any different than. You know what I mean? That there's not a more stringent process for the judicial system to get people.
Best is the ultimate, not the penultimate, it's the ultimate, best. So, and there also will be rules written about this. And behind there, I can't wait to read the rules. And Senator Weeks will be reading the rules.
Yes, ma'am. Right alongside you.
Yeah, I know. So for me, I think that the fact that we've gotten this far with this is terrific. So it's a far better step than where we were. So that best effort, working to maintain contact, but there are some people who really just want to disappear, and they do, which is unfortunate. And they don't accept responsibility perhaps, or they're afraid, whatever it is, we just don't know.
I acknowledge that.
Yeah.
Uh,
Tough.
My second hesitation was, that this bill didn't go through the judicial committee at all. And I know we talked about this the other day.
This is not their jurisdiction. I just say if we want, and then you can confirm that for us.
But the legal, here we have, Benza is also Office of Legislative Counsel for judicial. I'm just curious, the ramifications of this are so significant that I believe they're outside of health and welfare.
No, they're not. We deal with these things all the time, and the Human Services Board, we deal with all kinds of these. We dealt with this in S 192 with the forensic facility discussion. It is very sensitive personal information, and how to bring people to the table and provide due process for it.
And Senator Weeks, on that point, I mean, it's tough. There's almost like a little bit of like jurisdictional and cognitive dissonance, where, and the reason why I'm here, I work in child abuse and neglect is just in my portfolio, and there are similarities, but the fact that these statutes are in Title 33 and not Title 13 is really a good indicator of the difference in jurisdiction. Title 33 is really this committee Title 13 and some other criminal
Okay,
statutes.
well, that's a better explanation than saying that. That helps me understand why it's in here and not on there, so thank you. Appreciate it.
Question.
So just a question, Senator Weeks, is, you know, what would satisfy your concern? Do you have any wording that
Well,
put in?
so my hesitation.
Yeah.
As I tried to share earlier, is just that the positive contact of notification in the very beginning, that you've been accused. Okay, that, you know, I'll accept what I've heard. The second was just a brief pass through judicial, but that's not, you know, it's outside
Title 33.
I get that.
Welfare.
I had not heard that explanation before, and I appreciate that. Sure. So those are my questions, and I appreciate the extra effort to.
I think the good news is everybody's gotten together and heads are going north and south. This is a step forward.
If you would like to entertain a motion, I'd be happy to make one. I'm really thankful for all the work everyone's done over years.
Yeah, this isn't a new issue.
Was there that one
There was
little
that one
change that
change
needs to
though,
be made? No.
just adding to,
What draft would it be?
it'd be 2.1. Well, no, Kiki, did I send you a clean copy 2.1? Okay, so it would be 3.1 because I put it through editing one more time before we voted on.
3.1. We should get copies of it.
I'll work on that later today.
All right. I'm happy to entertain a motion if folks are ready to vote on it.
If we don't have the draft, though.
I know. We do have time on our schedule. And we could put it in for a vote tomorrow or Friday.
I do know, Kiki, you had initially sent me an 11:45 time. I could probably try and squeeze it in then.
Okay, let's try that.
Okay,
We'll,
I'll let you know if anything
Yeah,
changes.
then we'll have the final draft.
Okay.
Okay.
Motion more.
Today,
So,
today.
but I have
Okay.
upstairs.
All right, thank
I'm
you.
happy to do that.
Thanks, Ben.
Thanks, Ben.
Thanks for being late upstairs.
That's okay.
Appreciate it.
Yeah, my pleasure.
All right. Okay, there's Pepper outside.
Thank you.
This
Thank you very much.
Just a little factoid for today.
Thank you.
Today's date numerically increases the way forward.
I didn't hear what you said.
Yes.
Today's date numerically
Think
reads the
so.
same way backward and forward. It doesn't happen that often.
Oh, wow.
It's really interesting.
Yeah.
Thank you.
Thank you. Thanks for your work.
And Senator Weeks, I would just add, I have done my best to figure out a way to actually have a personal, it's just not possible. Not today. Well, I mean, we really looked seriously at doing certified mail. And then we realized that doesn't work either. We could not find a way to do it other than to build some shorts and we tried. So, but thank you very much for your comments.
Okay.
Yeah. You know, see a hard time. Emphasize.
We're looking at 6:12, which is not in our, it's online, it's not in our committee. It's in economic development.
If you let this.
Okay, so we can close the door.
Yeah, you gave us a copy Friday.
Yeah. Over. What's the latest draft?
It's as passed by the.
It's passed by the House.
Yes,
That's the one.
yeah, it hasn't changed. Yeah.
All right. As it heads up, folks. H612 is a bill that is in economic development. It's on the cannabis activity in the state. Part of the bill deals with medical cannabis and the medical dispensaries and related issues, also dosage levels, amounts of THC, not in here,
Not in here.
not in this. Out, okay, that's good. Too many things. And so, and Michelle is indisposed, and she suggested that James Pepper, from the chair of the Cannabis Control Board, go through the bill with us, and I accept her faith in you, and, so we'll have you go through the bill. We're interested in the medical sections, the healthcare sections.
And for the record, James Pepper, Chair of the Cannabis Control Board. Yes, and the medical sections were the process, the outcome of a lengthy stakeholder engagement process. We're in a report, they kind of came from a report that was asked for by this committee last year. So that report is posted under my name for today. And I was hoping.
Yeah, that's a good reminder. So last year, we worked as a committee and I took our recommendations into the Economic Development Committee and it came back and asked for some reporting information. So that is included. And that's the report you're talking about.
That's right. And I'm not going to walk through the
No.
report,
No.
but I was hoping before I get to the substance of the bill that I might just provide a bit of context to the conceptual framework of the medical amendments. We've been seeing a decline in enrollment in the medical use program registry. It started since we passed legal home grow in 2018. But the trend was accelerated by the emergence of the adult use program in 2022. And there's no real kind of floor in sight. We're at the point where the economies of scale no longer work financially for a standalone brick and mortar dispensary. We've seen one close already, and there could be more. I'm sure you all are asking yourselves the question that I usually get when I talk about this issue. Wasn't this trend anticipated? And why do we still need a medical program? So taking the second part first, there's aspects of the medical program that cannot be supplanted by the adult use program without significant statutory changes. These include protecting patient privacy and confidentiality, access to specialty products, including custom formulations, solid concentrates, and then any product approved by the CCB, which includes on the medical side, transdermal patches, suppositories, certain kind of capsules. There's also specialty services. There's personalized consultations and education. There's reservation systems. There's delivery. There's curbside pickup. And then, of course, there's tax-free purchases. On the question, wasn't this anticipated? It certainly was. This trend happens in almost every adult use state that transitions from medical to adult use. But the 2020 legislature wrote legislative intent in the tax and regulate bill that it was the General Assembly's intent to preserve access to products and services for medical patients. So when we took control of the medical program, we started holding a number of stakeholder meetings to see what we could do to continue to serve patients, hold them harmless with this transition to adult use. 3 alternative approaches emerged. The first would be just dramatically increase the economies of scale for the existing dispensaries by greatly expanding the eligibility for a medical card. The second would be just make adult use look exactly like medical use. Just mirror those regulations and statutes. But that would include eliminating all potency caps, allowing for delivery, things like that. The third approach, which is the one that we coalesced around, was allow certain adult use retailers that are willing to subject themselves to increased regulations around training and education and confidentiality and inventory tracking to serve registered patients. So that's the option that's what we recommended in our report. We believe that this is a patient-centric approach that doesn't fundamentally change the medical side or the adult use side. I'm going to just turn to the bill now.
Do you want to put it up on the screen? Can you do that?
Oh,
We can have you share.
I I have the sections, page numbers, and line numbers,
Good.
if someone wants to. I mean, I'm happy to
If you
share.
can share screen, she's gonna send you
Okay.
the ability to do that. Do you have the Zoom link? Do you have the Zoom link?
Sh-
You do want to do it.
I believe I've sent you things.
Okay, you have the Zoom. And we have the as passed by House version in front of us. Some of us do.
Yeah, I'm not seeing these. Sorry, I was supposed to be in economic development and any of this, so there's a lot of scheduling,
I think,
minutia.
yeah, they're actually leaving these sections to us.
Yes, exactly, right. They're just taking it up today. Simultaneously with you. We'll have it up, I can start while we.
I have it up. Yeah. Dave, do you
I
have
got it right on me. Oh, good, okay.
paper, old school?
You can start.
I've got paper too.
We got it both.
Okay. So, the medical sections, and I'm just gonna give you the overview, is sections 3 through 9, 13, and 14. The first is, so it starts on section 3, which begins on page 2. And, what you'll see is the first kind of mention of medical use endorsement, which is, essentially what an adult use retailer would kind of check a box on an application that they want this medical endorsement, and they would pay a fee, and then they would be subject to additional regulations, and it's additional permissions. The section 3 deals with prohibited products, and this is one of those situations where I mentioned that there are certain products that are only available on the adult use side or medical side that are prohibited on the adult use side. So this, starting on line 20, is kind of the notwithstanding, except as provided in a future section relating to retailers with a medical endorsement, and it authorizes them on the next page it removes the kind of potency caps for patients. In an adult use retailer that's serving, that with a medical endorsement that's serving a patient can possess and sell higher potency products to medical patients.
Higher than current.
Higher than what's allowed on the adult use. That's right.
Oh, 100.
Yeah, it's currently allowed on the medical side, these higher concentrated products.
So all of this is underlying statute at this point.
Except, yes, exactly. That's right.
Figure out what's.
Yeah, no, I'm a separate question, wasn't related to yours at all.
Can I ask a question? And maybe you're gonna get to this, but if somebody does get a medical endorsement, are there additional like training requirements for that?
It's not spelled out in here, but it gives us the rulemaking authority. It's in our report. Essentially what we're gonna do is we're gonna require that you have additional educational opportunities, and that will dovetail with the conversation with Dr. Klumpers later today. Additional training requirements for anyone who's interacting with the patient, additional kind of product segregations, and also we're going to require that people have ways to ensure patient privacy, and that could be through. We don't want to be too prescriptive because requiring essentially separate entrance is just not feasible for adult use retailers. But have sight sound separation, have either dedicated hours for patients, have kind of separate rooms for patients. We're going to have kind of a menu of options that people can do to kind of help protect patient confidentiality.
Okay, is that, and I mean, I'm specifically, that's great. Because if they are being a medical, providing medical cannabis, that, I mean, there's essentially like a pharmacy. And we have, you know, pharmacists are highly trained, licensed practitioners and regulated and I mean, you're a regulator, so I'm curious and concerned that these people wouldn't have the same kind of training that pharmacists would have. I mean, this is for medical purposes.
Right, and I think that it's important to underline that we're not asking for any additional authority than is already currently allowed to the medical dispensaries. We're just saying that we're starting to, their business model doesn't work to have a standalone.
Yeah, no, I get
order.
that,
So
I
we're
get
just
that.
saying, giving the authorizations that they currently have to a medically endorsed adult use retailer. Currently, there's no training requirements for the medical dispensaries, and that's just a kind of odd outcome of the rulemaking authority they were granted in 2014. And they just never included, the Department of Public Safety never included training requirements.
Really?
Yeah. And
So,
we-
yes, can I interject here? Because I do want to go through the bill, but your
Yeah.
question is a good one. And in 2014, all of this would have been discussed in judiciary. It was not in here. It's been a gradual transition for us to claim responsibility and for the medical pieces. And so now this is where you're identifying something that actually goes beyond what's in the bill. But at some point, as rulemaking changes, we might want to establish some criteria, but I don't know.
Well, I just want, when we get to the rulemaking
Right.
section, I wanna see, you know, it seems like it's all current law if you're not going to include, I mean, I think what I'm hearing from you is that you're gonna have suggestions about training instead of requirements of you need to do these things.
Let's go through the bill, because you're asking good questions. You're also asking questions about what's currently in statute, and let's understand how this intersects with that.
Okay,
Yeah,
And then we may have a suggestion for the bill going forward. So
yes, and on this point, this is a very critical point, because there's also no testing requirements on the medical side. They just weren't ever contemplated back in 2014. And so when the cannabis bill passed, the
I think we
2020
talk about, training for,
there's no training for the people interacting with patients, the employees.
So just, to Senator Hardy's comment, I know, well, I haven't been involved in this at all, so I don't know. So I appreciate you explaining it, and so I do understand.
And when the 2020 bill passed, it created the Cannabis Board and the tax and regulate system. It was also written in there that the Cannabis Board will soon control the medical program, try and harmonize the rules between adult use and medical. But no rule for the medical program can be more restrictive than the current rule that existed in 2015, which did not include training, did not include independent third-party testing. And so we asked for that line to be removed last year. You guys allowed us that. So we actually have the full authority now. We need to increase. And then the report that you asked us to do around appropriate dosing, appropriate communications with patients, appropriate kind of screenings for specific conditions. That's what we did all summer long. And that's how we ran into Dr. Klumpers, who's going to hopefully help us with this. The kind of training and education that's going to be required of anyone who's talking to anyone, not even just patients, but anyone who's kind of communicating information about cannabis.
So that's what I was thinking when we were talking earlier about what recommendations could we make, and it might be to come back with further proposals for statutory change in those areas. It's just to let folks know, it's been an uphill climb to get this discussion in this room. Saying like that.
Yeah, and the only reason we haven't just either through emergency rule or otherwise just immediately required independent third-party testing or increased educational requirements for bud tenders on the medical side is because the whole structure of the medical program is falling apart, it's crumbling under us. And this is the first step in kind of reimagining the entire medical program. So we wanted to wait to open up our rules around that when we had some clarity as to what, what the outcome of this bill was going to be.
So let's look at the bill and what's here and your what's suggested here as passed by the House. And then we'll continue the conversation about what we might do further.
So the next substantive section related to the medical program is in section 4, page 8, lines 19 and 20.
Getting there.
Well, okay.
So section 4 is about all the rules. And
And
it does,
this is just the whole thing.
These are all,
right, but it doesn't, there's almost no changes to it. There's just a one change at the very end of the rulemaking thing. On page 8, the top of page 8, that's the only thing that's changed, performance standards.
That's
those are all-
the adult use side, actually.
that's
Oh,
the adult use
okay.
cultivator language. So at the bottom of page 8, that's where we're talking about the medical.
Requirements for medical use endorsement.
Yeah, it's the lines 19 through 20. And maybe you're looking at the ASPAS version. ASPAS.
Passed by the House, yeah, lines 19 and 20G. That's
Yeah,
the
exactly.
only mention of it.
Right, and I mean, and if you want to get more specific there, you certainly can. I mean,
Let's go through the bill, then we write down your suggestions and we'll come back. We have a little bit of time here. We can always ask to pass over the bill if they pass it out in economic development. And so we can add our suggestions through an amendment. Best case scenario, we add an amendment while it's still in economic development and then it's integral to the bill, or we can present it on the floor as our choices. Yes.
Well, right, what the bill is asking to do is to combine the two types of establishments, so.
Hasn't been the problem.
I think it hasn't been addressed, like people who are dispensing things in the name of medical use aren't trained about what the medical use is. And I think if
So
you're
this is
combining it
good
with a current
discussion.
shop, there's.
Senator, I'm gonna ask, hold the discussion, let us go through the bill, this is our first look. We have other folks who wanna give us some testimony that'll help us with our decision making. So this, I know, there's a lot here, it's new, but it's also has stirred a lot of conversation, that's a good thing. So, all right, Pepper, so.
the next section, so yes, this section only grants us the authority to create rules around this medical use endorsement. It doesn't get specific as to what those rules should be. The next section, section 5, which is on page 10. This is what permits an medically endorsed adult use retailer. It gives them all of the same permissions that current medical dispensaries have. So this just allows someone with this endorsement all the same authorizations the current kind of standalone brick and mortar dispensaries are authorized to do. And you can see them all, I think, Michelle.
So this is at the bottom of page 10, where you're looking in section 5.
That's right. It starts with kind of selling tax-free cannabis. It goes on to products that are otherwise prohibited for non-medical patients. Quantities in excess, because a medical patient's allowed to purchase 2 ounces of cannabis or its equivalent, versus on the adult use side, it's a 1 ounce.
So this would allow for either a medical dispensary or a recreational use shop. Deal with both.
That's right.
Okay,
But I mean, I heard what
this is the place where that's at.
But I heard you say that there might be a separate entrance, so it'll be
That's right.
maybe the same building, but it'll be sort of different locations within the building.
That's right. I mean, this is how almost every other state operates. I mean, most states had a much more robust medical program before they transitioned to adult use. Massachusetts, Connecticut, you're required to get a medical license before you can open an adult use, since they have sight sound separation, they have separate entrances, they have kind of segregated products.
So this is interesting. Again, we're getting sidetracked because we're going on to how we're gonna approve the bill. But write your notes down so that we can come back and we can put some of this into are suggestions for rulemaking.
Very, very quickly. So
Yeah,
having been first pass on the bill, I thought that comment was very helpful, that essentially it's medical looking at adult and adult looking at medical. And I didn't get that from the first 20 minutes of the
no,
conversation.
that's what's here. Right here is that both the recreational shops and the medical dispensaries now could be combined. And a shop could say, I want to do medical, and a medical could say, I want to be shop.
Now I get it.
Yeah, and then the question is, how does that happen? You know, and how do you maintain the confidentiality for the patients? And so on.
Good.
Yeah, that's it. That's where that is. That's where this is, right? That's right. Yeah, okay.
And then the next section is the proposed fee for getting a medical endorsement. And you can see that in section 6. So the fee for a retail license is $10,000. If you want to have this additional authorization, it's $250. And that just doesn't take into account the regulatory burden of actually doing all the things to do this. So we wanted to make this relatively easy we didn't want to make it expensive, but we know that people are gonna have to subject themselves to additional regulatory hoops.
Well, and as long as you have people who are trained,
Pretty
work,
minimal.
yeah, as long as there are people who are trained, the requirements might extend to that, so.
The next section is section 7. This is unrelated to the medical endorsement. This was just a number of people coming forward asking to add ulcerative colitis to the list of qualifying conditions. And again, I don't pretend to be a policy expert, and then we've actually recommended elsewhere in our report that it shouldn't be the legislature that approves conditions. It should be a team of
Clinicians.
pharmacologists, clinicians, whomever else. Essentially the rationale here is that you have Crohn's disease, which is an inflammatory bowel disease. The other major, so whatever the rationale was at the time, it was determined that that should be on there. Ulcerative colitis.
It was
the
on
other.
there.
Okay, yes, all right,
I
sorry.
refuse to accept.
Yes, okay. Ulcerative colitis is the other major.
We're on,
Page 12, section 7.
Yeah, keep us.
Okay, I'll keep going, yes.
No, but no, keep us where we are.
Okay, yeah, this is section 7.
He's not practiced at this. This is not his job.
You're doing great.
It's hard because, I'm trying to give you the rationale, which is not something that the, Ledge
No,
Council.
we
generally do.
understand. We
Yeah.
understand.
Okay, so adding ulcerative colitis to the list of qualifying conditions that would allow a person to get a medical card.
And so this is an area we want to consider. And so there may be rulemaking about who makes that decision and how it's made, because we are not the medical experts here. And ulcerative colitis is something that has been placed in the legislation, and we don't know what the basis, evidence for that is. Okay.
I don't have a problem with adding it. It's just it seems weird that this isn't statute, that it's not just, again, this is doesn't seem like it's had because this committee hasn't done it. We wouldn't be listing in statute the diseases that can be treated with any other drug.
True, this is special because of the nature of the drug. And then there are no conditions under which these conditions are listed. There are no criteria, so
Right, I mean, it seems like usually we use the term medically
I
necessary.
need to cut myself off. I'm violating my principle. That's good. Let's keep going to the.
Okay. Section 8 on that same page extends the renewal term for a medical card, the expiration term, I should say, from 1 year to 3 years for all conditions.
So we did work on this when the original bill was passed in here, and so the link with the physician. Keep going.
Section 9.
Just let me ask you this,
Yes.
is there any requirement that the patient have an affiliation or relationship with a physician?
They need to have the qualifying physician needs to verify that the patient that they've examined the patient and they have this condition.
Okay, but there's nothing like a 2 or 3 months or 6 months or any
No.
timeframe.
Or
They're used to-
prescription, kind of.
Yeah,
Well, the problem with the prescription, even a recommendation, is that many physicians will not prescribe. I mean, you cannot
Oh,
prescribe. You cannot. I mean, there's no. It's not taught in medical school to even recommend cannabis for any symptom. And so, the system that we have, the qualified healthcare provider merely verifies that the person that they're examining has one of these 13 or so conditions.
Got it.
okay.
Section 9 on page 13, this lowers the fee. It tries to kind of equalize the fees for a standalone brick and mortar dispensary with the adult use fees, and recognizing the kind of the various economies of scale. Currently, there's 2,800 patients, and there's 5 medical dispensaries. Their fee for a medical dispensary is currently $25,000. For an adult use retailer that can serve the entire 21 plus population, it's $10,000. So this this lowers the one-time application fee to harmonize it with the adult use side, and then it reduces the annual fee for a standalone brick and mortar dispensary that's not medically endorsed. It's not an adult use retailer to $5,000.
Okay.
Section 13. Sections 13 and 14 were requested by the tax department. This is around an adult use retailer selling tax-free cannabis to a registered patient. And these are the protections that they asked for to make sure that those were tracked properly and that patient confidentiality was maintained. But that the commissioner could still ensure that they're collecting taxes properly for the adult use customers. And that's the end of the relevant kind of medical
That's it.
actions. Yeah,
That's-
I'm happy to do the rest of the bills.
That's enough. No, that's okay.
Is there-
We've got enough right here.
Yeah, can I ask a question?
That,
Are there, about the bill? Are there I see the tax thing. Are there requirements about patient confidentiality
In
current law
there,
or current rule?
yeah, my guess, I mean, certainly the healthcare records, we're receiving healthcare records we're receiving this verification form from the healthcare professionals, and our end, those are all confidential. I believe that there are in regulation for the medical patients, and certainly something that we are going to prioritize when we do rulemaking about patient confidentiality and the handling patient information.
Right, okay. It sounds like what my discomfort is I trust you. It's not that I don't trust you, but it sounds like so much is like, oh yeah, we're gonna do that in rule. But I don't see anything in the bill that's saying you need to do this in rule, except for this sort of vague thing that says you're gonna make rules.
so that's why we're looking at it. So we can elaborate a little bit, maybe put something in that helps guide the rulemaking process.
And that's certainly fine with me. I think the problem that we had in 2014 is that we didn't have independent testing, we didn't have education. And if you just say, make rules around patient confidentiality, educate, and then if we decide we need something else, like we need to limit something, I wouldn't want to be hamstrung by.
No, we get it.
Yeah.
Yeah. I mean, we can leave it,
Right,
but
yes.
and anything
Yes,
else you think is
yes,
appropriate,
right, yeah.
yes, but just. I'm
Maybe,
uncomfortable
maybe
with-
look
or
at that.
whatever. I mean, I'm uncomfortable with that. There's no training in set in the there, yeah.
So what I'm gonna suggest is we have folks in the room who are going to testify, and we're going to have their testimony on the record here. And I want to just say thank you for sitting in for Michelle.
Mhm.
Your expertise in this area is very helpful. And so, but don't leave us, your continuing involvement is going to be important, so.
Yes.
Yeah.
And I was.
Can you introduce your colleague?
I will, yeah. I mean, the Act 65 working group, we all coalesce around the need for better education and evidence-based, objective education.
Yeah.
That's current, because the pace at which the science around cannabis changes is dramatic. And, Dr. McLean who was the kind of academic detailing program representative for Access to Five Working Group. His job is to evaluate the academic rigor of all emerging science. He said doing this for cannabis would be a full-time job, and the academic detailing program probably can't get involved because they don't have the resources. Well, our path led to Dr. Linda Klumpers, who actually has a PhD in neuropharmacology. And
Why don't we have Dr. Klumper come up?
okay, I guess.
To offer testimony, I know, that would be very good, and then we'll go to, VMS after that.
Okay.
And James Dumont is here, and you have recommended Dr.
No, our witness is Dr. Stout, who's on Zoom.
Okay, he's on Zoom. All right. Got it. And we'll go to him after that.
Oh, no.
Yeah.
Okay, it's a her.
To her. Got it, so. All right, so let's do that. This will provide some continuity between what, Pepper, you said, and then what the working group did. And I know last year when we put the working group into legislation, and Dr. McLean graciously accepted that work. And then we did talk about some of this at the annual meeting for the drug detailing group last couple of years. We talked about it and how they can or cannot educate physicians and others. We'll listen to you. Thank you. For the record, we are.
Okay,
Let's introduce ourselves briefly. Start with Senator Hurry.
thank you. Hi, I'm Senator Ruth Hardy. I represent the Addison District.
I'm Senator Terry Williams, I represent Rutland District.
Jenny Lyons, Chittenden Southeast.
Morning, 8 weeks, Rutland County.
Good morning, Martina Rockula, Burlington, Winooski, Colchester, Essex. Okay, Chittenden County.
Okay.
Linda Klumpers from Colorado, so maybe that's why you confuse doctors, let's say, because the person who dialed is also from Colorado. I do have some slides. I don't need to show them, but if
Oh, no,
you have
right.
an HDMI or something that I can.
Have you been sent the link?
No.
Can you put them on? I don't have them on here. I don't have them. Have you sent them to Kiki? slides?
The slides, no, but I can do that right
Yeah,
now.
I'll do that. And then we'll get them on our webpage.
Okay.
And then if she sends you the Zoom, we can coordinate that a little bit.
Okay.
And if need be, Kiki, you can scroll through.
It's takes a bit to load the. Yes.
So we'll be pushing back consumer privacy. The consumer privacy bill a little bit. Whether we get to all that testimony today or no, we might have to put it off until Friday.
It's currently loading. Yeah. I mean, I can use this time while it's loading to just introduce myself.
Please do.
But you don't need that. So I have a background in medical biology and neuroscience. I am a clinical pharmacologist. So that means that I am trained to study drugs, new medications in humans. And my PhD was particularly in the drug development of cannabinoids. And yes, I have studied the compounds that are in cannabis, but I've also studied, that was a main theme of my PhD research, were anti-cannabis compounds. So currently they're under development for intoxication reversal of cannabinoid intoxication. That is something that the emergency department of the University of Vermont is also involved with. They're part of a study that I'm working on. But at that time, these drugs were developed for obesity treatment and substance abuse treatment. And then we are talking about 18 years ago. That's how long I've been working on cannabinoid pharmacology. Also, still loading, I work with Verdian Science, that is a pharmacology consulting partnership. We're with a little team of 8 people, and we help companies that develop drugs. And I teach at the University of Vermont. I am a research assistant professor at the pharmacology department of Mark Nelson, where I also teach on cannabinoids and on psychedelics, and then the pharmacology, because that's my specialty. I do some independent studies next to it. I've got, together with 2 other scientists, we applied for a grant in the Netherlands, and we got a $2 million equivalent grant to study the compounds from cannabis plant THC and CBD, because there are a lot of in the cannabis space, a lot of stories about what all these compounds should be doing, and CBD will diminish the effects of THC. Is that really true? So we wanted to research that, and we found no, it's actually quite the opposite in the dosages that we.
So did you set Kiki your slides?
It's still loading.
Oh, your slides are still loaded?
Yeah, I'm keeping an eye on it. It's almost there.
Okay.
And so I'm doing that research as well. It has loaded, so now I click send. So now it's loading the set. So we'll see. So
Why don't you just go ahead and start with your slides, and then
sure.
We'll pick them up as they load.
It's been sent.
Do you have? Oh, you can look at your slide.
Oh yeah, I can keep it on. But yeah. So that is the. That is what I do. And I came to the United States 9 years ago because I'm obviously not from Colorado originally. And at that time, I noticed a few things, because 9 years ago was around the time that Colorado started allowing adult use. And at that time, I had already been in the space for 10 years. And I saw that there were a lot of people who were really trying their best, and I saw this as an opportunity of, oh, this is a new area where people can use their best practices. But of course, I'm way too naive in that, because that's not necessarily what people really want to do. And then I noticed that there was a lot of education, let's say, that was being done, but that was mostly done from the perspective of people who were emotional about the whole thing or had financial interest. And I thought, me as a scientist, I like to really look at the science and the evidence and educate people that way. So I came up with the idea of educating people in an objective way, and that is how Canify, that's why I'm sitting here today, how we started that.
So given our time, we're having difficulty capturing your slides. So you can try and send those to Kiki. And it would be helpful for you just to give us your testimony at this point, because we've got other folks in the lineup.
Sure. They should have arrived to people already, but if they have not, I can also show images on the screen if needed. So what is Canify? We try to educate people in an objective way. We have pages with educational information, but the central part of Canify is quiz. And what that is that the quiz contains questions that all have a particular reason, and most of the reasons are of pharmacology in nature. So people fill out the questionnaire with the symptom they're interested in and their personal characteristics. And from the answers of all those questions, you will get a personalized report. And that report gives an overview of the scientific literature that is available for your symptom. If it's not available, we will say that as well. And we explain literature hopefully in a way that people can understand it well, because that is of course always a big issue. And that solves a few issues, namely one, when patients start trying to look for the science, it's really hard to interpret. The second part is when the patient goes to the dispensary, They deal with bartenders who are very passionate about cannabis and have a lot of their own experience, but they do not know anything about medical conditions and about cannabis science, really. And then you also, as a patient, can go to a physician, but then the issue is that a lot of physicians are not comfortable discussing this topic purely because they do not have education. So there you go. There's this, this big gap actually that patients and everybody actually, they want information, but where to get it from in a way that's understandable. So that is how, Canify can help these different groups of people. So you have the questionnaire, you get your report, and that overview, you can save that as well. And then after that report, of course, the question is, okay, what to do next? Because the report gives you a narrative with the literature, but it also gives you a report summary on the compounds, starting dose, and the administration method that has been shown to be effective in this case in the literature. But the compounds or the medicines that are used in clinical trials are definitely not the same as the ones that you find in a dispensary. It's another issue. So we try to help people translate the relationship and the differences between the compounds used in the studies versus what you can buy in a dispensary by means of a matching score. We thought that that is the most natural way of showing people what the differences are exactly. I can explain how these all work. So we have worked on the literature selection, we've worked on the algorithms for the matching score, and we've all done that in-house. We do not include, so indeed the input, where does the input come from? That's of course another question. That is from the scientific literature. That we do not just copy whatever we find and we put it in a report, but you're actually pretty familiar with our methodology because I saw that you have a really nicely laid out evidence, key questions to assess the evidence overview, and that's exactly what we use as well. I really like it. It's about the quality. Who did this study and what are their conflicts of interest? Very important because for sleep apnea, there's a lot of evidence, but it all comes from the same group that holds the patent for THC and sleep apnea. And is there reproducibility? Or is this just a one-time thing? So we are selective in what evidence, what literature we include in this whole thing. So that is how it works. How it's been applied in the past is with healthcare providers, with dispensaries, actually many different parties. And I understand that the most important parties in Vermont at this point are the bartenders and the healthcare providers. So we can train bartenders, and it's really funny to see because bartenders indeed think they know it all, but if you start training them, they are actually pretty hungry for fact versus fiction, and that's really nice to see how interested they are in learning more. So we can train the bartenders to actually help patients fill out such a questionnaire themselves. In case they have questions, but there's also another model. This has been used by healthcare providers as well. At the Rocky Mountain Poison and Drug Center in Colorado, it's now called Rocky Mountain Poison and Drug Safety. There was a 24/7 hotline. It's not being financed anymore, but they used to help patients go through. They took them through the questionnaire on the phone to understand what was going on with regards to their medical questions, or in case of intoxication. What happened? Where did it go wrong? So that those are some examples of how this can be used. Indeed, in a physician's office, a physician can go through the questionnaire with the patient. And this is actually something that we try to study and we try to apply for grants to really understand the impact on the physician confidentiality and what this does for the patient. And right when we wanted to start the study, it was March 2020, pandemic hit, and the university partners we were working with had to pull out. But I'm currently discussing this with the Vermont Medical Society to hopefully study this with them. So that we are talking about how to best implement it and also how to optimize this, let's say. I've been talking a lot, but if there are questions.
No, this is very good. And this is helpful because I think what you're doing is you're beginning to structure some of our thoughts around the rulemaking process and what we can add to the bill. I made a long list while you were talking. So it's-
Oh.
Go ahead.
Yes, thank you. This is really interesting, but I'm confused is what you do the proposal for how to, and maybe this is a question for James, like, is this your proposal for how to deal with the training and?
I would like to incorporate Canify, not just in the medical dispensaries or these adult use ones, but incorporate into because every consumer, this is a cannabis misuse prevention tool in my mind. This directs people away from the products that may cause a problem if they have predisposition to schizophrenia or they're taking a heart medication or something along those lines. It'll flag products that they need to avoid. My hope is to have Dr. Klumpers and Canify train all of our bud tenders and then potentially form a curriculum for continuing medical education for physicians if they want it, a voluntary program. Because to me, we all coalesce this Access to 5 working group around the need for evidence-based, objective, current education. And so, yes, the answer to your question is yes. This is have a Canify portal at every adult use retailer, have bud tenders trained on how to use it, and take them out of the equation essentially. Don't have them pushing products on people. Have Canify be the kind of portal where a low information cannabis consumer can get the kind of information they need. If they're saying, I want to substitute a sleeping pill or something like that.
Okay, I guess I don't feel like I know enough to know, because I feel like I'm very just skeptical generally of people coming in and trying to like push an app. I mean, you should see all the emails we get from vendors being like, do this app for X, Y, or Z medical thing, and it's not always medical, but so you sound great and credible, and I trust Pepper, but I also am skeptical.
All right, so I'm gonna suggest, this is good conversation, and I'm not gonna go through what I wrote down, but it's similar to what you were just saying, James. But it goes a step further and it asks, what I would ask for is we need to hear testimony from others. And then any rules that are promulgated, we would need to review and hear before they went to the real world. So, that's my thinking at this point, but we have other folks to listen to, and your information is now up on our webpage, which is great to know. So let's do this. Let's move on to who's next? Actually, Jill, do you mind just waiting until we have folks who are not usually in the room with us, so we can do that? James or Dr. Stout?
Yes, thank you.
Yeah.
I'm Jim Dumont,
Please.
practice on Bristol, but I'm ceding my time, so to speak, or hoping you'll listen to Dr. Stout, who really is an expert on this. I'm just a lawyer. So you don't trust me, anything I say. So I'll get out of the chair and Dr. Stout, I think.
Oh, thank you. And we have something from you online, which
Yes.
is great. This is good. We'll read it.
Thank you.
And Dr. Stout, thank you for your, for being here. Where are you right now?
Thank you. I'm in Salida, Colorado, in the middle of the mountains.
So I hope that we didn't get you up too early just to wait for your testimony. We did. I can tell you.
No, I had to feed the horses, so it was good to get up early.
Okay, well, thank you for feeding the horses. So why don't you, we've introduced ourselves earlier and I'm hoping that would suffice. And then if you could introduce yourself for the record and provide us with some testimony. You've been hearing the conversation as we've gone through the bill.
Yes, thank you. I really do appreciate being able to talk to you today. Pardon me. My name is Libby Stout. I am a board certified psychiatrist in Colorado. I've been specializing in addiction. I've been practicing in this field of behavioral health for the past 34 years. I have a great deal of experience working with people who have had bad outcomes or problems resulting from cannabis use. I was really fortunate that for 20 of those years, I was the medical director for a pretty awesome program that was at the state hospital in Colorado, actually funded by the state of Colorado, a program that doesn't exist anywhere else in the country, but a 90-day inpatient treatment program for people with co-occurring issues like mental health and substance abuse problems. And 80% of them were referred as a condition of probation for their legal charges related to their substance use. And we had a really great outcomes. I mean, we, with 90 days in the hospital, a very intense program, we had up to 80% successfully completing and going on to do well in the community for years. And when Colorado legalized medical marijuana, I wasn't that concerned about it. I actually really supported the idea of decriminalization. And in retrospect, I think I wasn't concerned about it because at that time, the highest THC potency was 5%, and we had no concentrates. So there was none of these very high potency products. However, in 2014, when we opened the doors for the dispensaries for adult use, and then we got a law that said people on probation can use medical marijuana if a doctor recommends it. I started seeing really serious problems that I was like shocked. We started seeing worse and worse outcomes. People were very cognitively impaired by their use. And these people are now using really high potency products. And so our successful completion rate dropped almost 50%. And I started seeing things that I had never seen before, like really severe psychosis, really severe delusional symptoms. And these were people that the only drug they were using was cannabis. I started seeing people with cannabis use disorder or addiction to cannabis. That was their only drug. And I had never seen that before because I also agreed that in the past, the old time marijuana wasn't addicting, but these high potency products are extremely addicting, and people are having cannabis use disorder. In fact, the most recent research shows that for people using medical marijuana, 1 in 4 develop cannabis use disorder, meaning they get addicted to it. So my experience with patients is once somebody is addicted to it, it's an extremely difficult drug to get off of. I really do believe that the biggest disservice that has been done to the general population is allowing the cannabis industry to market and heavily advertise these high THC products as medicine. There has been absolutely no research supporting the use of any of these high potency products. I'm validated, legitimate research, randomized double-blind placebo-controlled trials for wax, shatter, high potency hash oil, edibles for medical purposes, but they are still sold in the medical market. And in fact, in Colorado, there's absolutely no difference between what's in the medical market and what is in the adult use market. And here you do have a difference. And you're talking about increasing the potency in all of your dispensaries, or at least expanding it dramatically. So research has been done. There is research supporting the use of medical cannabis, but it is all less than 10% THC. And and your pharmacist there, she did talk about this. Most of the studies have been done on stuff that's not available in the dispensaries. We don't have those studies, and we have exactly the opposite, where we have a lot of studies from around the world showing that these high potency products are creating a lot of problems like psychosis, suicide, violence, and this cannabis use disorder. So in my experience, no one needs the high potency THC. Except perhaps if somebody is at the end stage of their life. I have no problem with that person having high potency THC. However, what most people who believe they need the higher potency have experienced is they have actually developed cannabis use disorder because they have developed tolerance to the drug and they start having withdrawal symptoms. In fact, most of these studies on medical marijuana have shown that the majority of people are experiencing withdrawal most of the time. And so they have to keep taking a higher and higher dose to achieve the same effect and to avoid having the withdrawal. So my biggest concern is with young people. So people whose brains are still developing, and we know that from neuroscience that people's brains are still developing until the mid-20s. And right now you have limited access to these very high potency products. Your bill is talking about expanding this access to multiple places, which will expand the access to the young people. And I'm really afraid you're going to end up in this public healthcare crisis that we have experienced in Colorado. And hopefully you can learn from our experience. You actually have very sobering data from your very own Alan Bundy, a doctor at UVM and Dartmouth, who is showing that 10% of the youth who go through treatment in a state-of-the-art treatment program for a cannabis use disorder, only 10% are able to stay abstinent at the end of 12 months. This is an extremely addictive drug, and the younger people start, the much stronger it is in terms of developing an addiction. It is extremely easy to get a medical card. This is very true in Colorado, and I know it is very true in Vermont, because you actually have the ability to, for an 18 to 20-year-old, to get a medical card. This is without any parental consent or knowledge. So these are people that are still, their brains are developing. They can go online, and this is into states that the doctors are not even working in Vermont. I mean, you can go outside of the state on a Zoom, get a medical card like in 5 minutes on a Zoom. That is not a doctor-patient relationship. And because this is a recommendation, not a prescription, then the providers that are making the recommendation don't explain what product they should buy, what potency, what route, what frequency. They leave that up to the patient and the bud tender. And then they never follow up with the patient to see if it's helping or causing any problems. I hope you have read Laura Stack's testimony about her son getting his medical card at 18 without any medical indication, and how he ultimately developed psychosis and died by suicide. Sadly, in Colorado, it became a rite of passage for people, 18-year-olds, to get their medical card. So these are kids that are still in high school. They are able to get a medical card extremely easily. I've seen kids get them for a broken thumb, a broken finger, and then they can go and purchase whatever they want, and then they can sell or share their products with their friends. We developed so many problems with this. Hundreds of families were affected that we ended up having a bill in 2021 to put some controls on the concentrates. Representative Julia Mobley carried this bill, House Bill 21-1317, and she gave testimony on the floor of the House to her colleagues. And I really hope that you watch the video that James Dumont gave you regarding her son's experience with psychosis. One thing that we were able to accomplish with this bill was we were able to put some limits on the amount that could be purchased in a day. Because prior to that, even an 18-year-old could purchase 40 grams a day. And the biggest thing is we could put controls on looping. And you have no controls on looping. So I don't know if you know what that is, but what looping means is you go to one dispensary and get the amount you're allowed to purchase for that day. And then you go to another dispensary and then you get the same amount. Then you go to another dispensary. And right now, if you only have 5 that can do medical, that's really limited the access. But if you have 75, then somebody can go from one to one to one to one, and they can amass an incredible amount of these high potency products and then divert that product to others. So I believe that if THC, especially high potency THC, is a medicine, then it should be treated as a medicine. There should be much stricter controls on those who are handing out medical cards. There should be a doctor-patient relationship in that the doctor has physically examined, not Zoom, but actually physically put their hands on the person to determine the severity of their illness, like they have the severe debilitating illness that they're recommending the medicine for. They should get medical records. That doesn't happen. Most doctors don't ask for medical records to document the severity of the illness and communicate with the patient's other providers. Because one of the biggest things that your lack of education is very serious, because one of the biggest things we're finding now is the drug-drug interactions between cannabis and all sorts of medications. So there are negative interactions with multiple medications that a really well-trained pharmacist would be able to say, yes, these are the interactions, and you can't take this, you can't take cannabis if you're taking this medication, or you're going to have these side effects, or your medication isn't going to work. And then really there should be communication back and forth between all the providers. And then they should definitely ask for history of mental health problems or symptoms of mental health problems or substance abuse problems, because these people are going to be exacerbated by using this if they don't get a really thorough history. And then they should be required to follow up the patient. I mean, most people only see the recommending person, whether it's a doctor or a nurse practitioner or whoever. In Colorado, it's just a doctor, and they have to have an unrestricted DEA license to do this. And I think that's really important. But they only see them once a year because they renew their card every year. Now I'm hearing you may go to 3 years. So they're not having any follow-up. So they have no idea if the patient is experiencing benefit from the medicine, or if they're experiencing side effects, or if they've had problems. And I think that's why a lot of the recommending doctors don't really realize the problems that can arise, because they're not following the patient long enough to know that the patients are having problems. So I have to say, there are doctors I know who are doing this responsibly. They do it right, but that is not the norm. There are physicians that are making hundreds of thousands of dollars a year by just doing 5-minute Zoom calls with people and giving them their card. And that is something I've seen in Vermont, that people are being recruited. Physicians are being recruited to make an incredible amount of money just so they'll give a card. And I think there's really something really wrong with that. I would be happy to answer any questions you might have.
Thank you. I know Colorado has had a long history with all of this, so your input is extremely helpful. Questions for Dr. Stout?
Well, I can ask a question. I'm not sure it's for Dr. Stout, but it seems as though there many issues were brought up in your testimony. Much appreciated. It's obviously a complicated, to a certain extent, a complicated issue. I guess I want to bring it back to the bill and what are we trying to get at here? Because I heard issues with, the looping. I heard issues with the levels of the THC. I heard issues around the medical, interaction. Yeah. So.
Well, that's where we'll get to that. Write those things down, identify those things, because those will be important for us to put together in some amendment one way or another. So I think questions of clarification at this point. Thank you. Thank you very much. And thanks for your patience.
You're
This
welcome.
early day for you. Probably about 5 o'clock in the morning when you got up ready to go. So,
That's true.
yeah, I get it.
But she had to feed the horses.
Yeah,
Right.
and the horses are out.
She's a farmer.
All right.
All right. Well,
I
Thank
do wanna, I thank you so much, and I do wanna finish all the testimony that we have on this topic this morning. We will come back, as a committee, well, we'll have it on the agenda, and we'll have an opportunity for the full conversation and what we think might help the bill or improve the bill, so we'll do that. It may not be until Friday, but we'll do it. So, I'm gonna move on to, Jill Sudov-Giran for Vermont Medical Society.
Good morning, Erin with Vermont Medical Society, and thanks for taking our comments on this. So I feel like a lot of questions have come up, and I just wanted to remind people of a couple of things. And one of those is that there is no prescription for medical cannabis. The way it works is that your physician qualifies that you have the symptoms that are in current law, and then you're able to be on the registry, and you have to go through a verification form that goes to the CCB, and then they say that you are on the registry. So that's how that works. And then also just thinking about the potency caps. So the medical program does not have the caps that the adult recreational shops have, which is 60% for the concentrates, the solid concentrates, and 30% for flour. So what we're really talking about is that there are some medical patients that have been that have access to products that are not on the recreational market. And so what this bill is looking to do is, because there's so many patients, so right now we have about 2,800 medical patients statewide. And that has decreased pretty rapidly. James was saying to me the other day that it's decreasing up to like 100 patients per month. So we've got 5 dispensaries. We have 75 recreational shops, or over that maybe, at this point. So access is no longer the problem. In 2004, that's what the medical program was looking to get, is that people would have access to this. And so now we are looking at this medical endorsement, and the VMS is asking why. I mean, we understand that there are patients that have preferred products, but you're talking about creating this whole new system for very few people. And so I would just put that out there. And then, like Dr. Stout was saying, there is concern if you don't have, in 2004, when you started this program, there was the requirement for a bona fide healthcare relationship. This exists in all kinds of states, Massachusetts, Rhode Island,
Maine started it.
Maine. So basically you're trying to avoid this medical card mill and any sort of loopholes, which, you know, when we started the recreational market, we were saying, let's get rid of the black market. So this has the potential, just, you know, particularly for the 18 to 20-year-olds who I just, in my testimony, I include, there's this NUG MD, which is now on the dispensaries. And so NUG MD says you can get verified in a couple of minutes. And so it's not that real relationship. And we're talking about chronic conditions, we're talking about pretty severe symptoms, and we think it should be evidence-based. And so those are some of our concerns.
So I'm looking at your testimony, because I'm trying to consolidate our time a little bit, but.
Yeah.
So your concern is the relationship and then the level of, THC in recreational?
We've
I know.
always been concerned about high potency products, but the House retained the potency caps and we support the retention of the potency caps.
Okay.
But what we're talking about right now is increasing access to these high potency products, and you need to do that safely. It needs to be done with rulemaking, and we think you need to put back into statute the requirement for a bona fide healthcare relationship. Because we think if you're going to have a medical program, it should be evidence-based.
Should be a medical program.
Yeah, because we already have the access. So, and just to talk about the demand for these products, it's pretty low from the medical patients from what we've seen. There was a patient survey in which 645 medical patients responded that they mostly use smokable flower and edibles, and only about 15% of medical patients that answered that question use the 60%. So we're talking about 3% of the 2,800 people that want this high potency. So we're not talking about a huge demand here. So that is what we're saying. Seems like a pretty big step to create this medical endorsement process, but if you're going to do it, please put back the bona fide healthcare relationship. And then we also, we want things that were in the medical programs, specifically around patient confidentiality, to protect patient health information, requiring all the medical advertising to follow the current rules around that. And then delivery also must have that, verification, because that's going to be important. Also, we need to really be thinking about that delineation in the brick and mortar shops and even online too. How are you delineating the sales of medical cannabis from the recreational, and how are you not promoting access to these high potency products as well? And then we agree with James. We think that this isn't in the bill, but it was in the Act 65 work group that we took part in, is, really considering when we started the medical program, there was a Cannabis for Symptom Relief Oversight Committee. It was called the Marijuana Review Board at the time. Obviously that's dated, but think about having an independent board making these decisions around qualifying conditions. And really taking that legislative burden off of you and, putting that more to.
We'll be happy to do that.
That would be great. So we don't support adding any conditions at this time. We would support a different process. And then we also don't support extending the renewal for 3 years for all conditions. Again, the standard for most states around us, Maine, New York, Connecticut, Rhode Island, Massachusetts, is a year. And
Just like any prescription drug.
right, I mean, if you don't want to have the renewal fees, that's fine, that's a fiscal decision for the state, but it's really about, medical care, and if you have these chronic conditions, you should be seeing your bona fide healthcare professional regularly and having these conversations.
Okay, thank you.
And I also submitted the 2022 CCB patient
The questionnaire.
form,
So,
and that has the relationship language in there that was previously in statute.
okay. Thank you. Good questions. Go ahead.
Thanks, thanks, Jill. I'm just looking at your testimony, you didn't submit any suggested language changes to the bill, did you?
The language would largely be from that form, but it would, and so I can just take that the language around what was in the statute previously that has the definition of a bona fide healthcare relationship.
Yeah, I mean, I don't know if Michelle needs that or not, but I share your concerns, like if this is actually a medical program, which is what it's being called, it needs to act like a medical program. It's not something that.
When it started, it was a medical program and then it morphed into recreational and we
Right.
still have medical.
And I'm not, if we're gonna still have a medical program, and I do believe there are medical uses for cannabis and that it provides relief and care for people who have very serious chronic conditions. I don't wanna, downplay that, but I also think that if we're gonna call it a medical program, it needs to follow the same kind of guidelines to the extent possible that any other medical care would follow. And I'm uncomfortable with it being moved into recreational shops without having the
Guardrails.
appropriate guardrails, oversight, training, all of
So
that.
I'm gonna suggest, I know this is exactly the conversation we wanna have.
I know we have other bills.
I know, sorry.
Yeah, I was just gonna say, I think that, that's the most fair for patients, right? So people are expecting that because they can get access in the recreational market. So if they're choosing to go and to get on the medical registry, then they want to have, the best option.
Right, well, and there are higher potency, in the medical portion, it's higher potency potentially. And I think that I hear you and others with concerns about under 21 and using that. So if you're under 21 and are trying to access the higher potency, there has to be a really good medical reason for doing it, not just, we did a bill that got vetoed in here that was trying to protect.
So we're gonna move on. I appreciate everyone here and having some language suggestions that you might forward to us is helpful, each one of you who has testified. And because we'll come back to this and we'll get back into a discussion about how to educate folks who are actually involved in dispensing or selling, the level of THC, and the physician-patient relationship, all of those things that haven't been fully addressed in the past. Whether we can come up with full language on that is another question. We might come up with some direction to bring us back the rules, and then we can act on those. That might, to me, that might make a little more sense. So let's think about what you might want to have committee, and then we'll come back to it. A lot of good testimony. So, and while we've been talking about this, we've been talking about confidentiality and privacy. And it just so happens there's a bill in economic development on privacy, and John Gray is here. If you want to take a break, yeah, we'll just take one. We're gonna keep moving along. John, thanks for being here.
Sure.
All right, we're gonna take a 2-minute break. We'll come back.